Hey, welcome to the Empower Series, everyone. Y'all, we've been talking. I didn't know that you weren't online, but now that you're online, this is the place you need to be. My name is Clifton Johnson. You're watching the Empower Series. For those of you who are new, welcome. We are going to talk about estate planning, and this is what is very, very important and dear to my heart. I was just telling everybody here that after this program, I'm going to hop on a plane and go to Kansas City, Missouri, because my cousin, Archie, has passed away last week, and I'm going to be with family. And so this is estate planning. At some point, we are not going to wake up tomorrow. We are already winning because we're up. But there's somebody who went to bed last night and they're not here. And they had plans this morning, right? And their family members are going through trying to figure out what to do next. So this estate planning workshop is about creating peace of mind, not only for ourselves, but for our family, people we love. Over half of Americans do not have an estate plan. Isn't that crazy? But even more importantly, there are some people who are waking up and not able to do what they used to do. And that means they're not able to take care of their finances, maybe they're eating, they're traveling. And so there are things that need to be taken care of now that we can plan for, of who do we want to be, who's responsible enough in our family to take care of these things, right? And then more importantly, who we don't want to take care of things. I don't care who wants to take care of me, but I don't want to be this person. So that's what we're going to talk about today. So thank you for joining us. We have a speaker. Her practice is on estate planning. If you want to look her up, her name again is Rwan Hardesty. I always mess up names. Say it again. Yeah, I apologize. But she is an estate planning attorney. She graduated from SMU with a law degree in 2009, has been practicing in Texas since 2010. She not only specializes in estate planning, but she does family law, which is much broader than just estate planning. The most important thing, though, for you to know is that she is a member of the J.L. Turner Legal Association. She's also a member of the Rising Star, which is in 2019 and 2020, she was assigned as a Rising Star, which means that she has achieved a high level of expertise in a special area of law. So she's here today to share that knowledge that she shares with her clients with us. And so we're blessed to have her here. Get your pens and paper ready and give her a warm Empower Series love welcome to our speaker today, Rwan Hardesty.
Thank you, everybody. I'm going to stay here at the podium today just since I have all my notes in here. But my name is Rwan Hardesty. And I want to make sure that I can be seen on the camera. Are we good over there? Okay. So thank you, Clifton, for inviting me. Poor Clifton, he sent me messages. I said, yes, I'm available. And then I went silent on him because I'm busy. I'm a family law attorney. I have a lot of clients that need a lot of help because, in the family law world, we're dealing with child custody issues and financial issues and estate planning and probate, and things kind of happen very quickly in the law. So he did a wonderful job putting my face on that flyer without me giving him anything. It's very disconcerting to see that flyer, but we're all good. So I wanted to start off this this series or this discussion about wondering who in the room knows what an estate plan actually is. Anybody? No? Kind of, sorta? A little bit. Okay, so we're here talking about estate planning, but in a broader sense, I'm also going to talk about probate, which is kind of part of estate planning, and I'm going to talk a little bit about guardianships. I've asked a couple people here to remind me to talk about guardianships. So estate planning is the way that we choose to distribute our assets to the people that we love after we have passed. And so it's deciding in advance who we want to give all of our things to. Obviously, some people have a lot of stuff. Some people don't have a whole lot of stuff. So today what I'm going to talk about is more geared towards people that may not have a lot of assets and how to get past what the probate process is, which probate is where you have to go to court and you have to tell a judge, hey, all of this stuff, this person has died and now we need to distribute all these assets. Sometimes there's a will, sometimes there's not. And we'll kind of talk about that. And in some instances, you might not need to go to probate, and I'll talk about that. And in some instances, you absolutely need to go to probate. So, everybody, by a show of hands, who remembers when the artist formerly known as Prince died? And I'm just going to call him Prince. Just one person? A lot of people. Everybody in here. He died without a will, right? Can you imagine having, I'm assuming, billions of dollars and people not knowing where your money's going to go? Whether it's going to go to charity, whether it's going to go to family members. Who are your family members? How many heirs do you have? You know, all of those questions need to be answered. And he had, royalty rights, song rights, all of that stuff. And so his estate was significant, and his poor attorneys had to figure it all out, right? So that's an extreme situation. We're, people of, moderate means. We still need to think about our children and our heirs and everybody that we care about. Even if you want somebody to inherit off of you that isn't a family member, you need to think about that. If you want to give something to charity, you need to think about that. So, my first slide is, what is an estate plan? Like I said, it's making a plan for how you want to divide your property after you die. And it's deciding in advance who should be in charge of your medical and financial affairs, because estate planning isn't only about after you die. There are documents that we also deal with for when we become incapacitated for some reason. Say we get dementia, or we're unable to take care of our bodily selves anymore, or we've been in the hospital and are unable to speak for ourselves. We need other documents in place for those items. So these slides, let me tell y'all before we get fully into them, have a lot of words in them. Just listen to me, don't read the slides. I assure you, you'll get all of the information from me. So this is more for me to make sure that I'm on track. Okay, so estate planning typically starts with a will. So a will is a document that sets your intentions for how you want things distributed. Could also be who you want as your guardian of your minor children, if you still have minor children, and other important conflicts. So typically, people decide to put together a will because they want to make sure that their family members don't have to deal with the stress of either arguing or figuring out what you have, or just trying to streamline the process. Having a will does not mean that you don't have to go to probate, okay? So don't listen to anybody that talks to you about, well, if you have a will, you don't have to go to probate, okay? You still have to go to probate if you have assets that need to be probated, all right? So, and we'll talk about that in a little bit. But if you don't have a will in Texas, then you would be considered a person that has died intestate, and that's spelled intestate, intestate. And what that basically means is I've died without a will, and now the state gets to determine how my assets are going to be distributed based off of a court. So, or going through the probate process. So, if you don't want that to happen, put a will in place, okay? And even if you have a will, and say that you don't have a ton of significant assets that actually don't have to be probated, at least you'll have a document in place for your family to say, okay, this person's going to get the car, this person's going to get the house, this person's going to administer this part of whatever it may be, okay? If you have life insurance proceeds or whatever it may be, you can talk about those things. All right, so don't assume if you are married, and this is being intestate, dying without a will. So don't assume that if you are married, your spouse is going to get all of your stuff. What actually happens is they get basically half of your stuff, and then the rest gets distributed to heirs. And heirs are your children first, and then it can go either down that line, children's line. It can also go across, so it can be siblings. Sometimes it goes up to your parents if they're still alive, okay? So it just depends, and that's when attorneys get all involved, and we have to figure that out, and trust me, sometimes we're very confused as well. We have nice charts that tell us what to do. All right, so what does it mean to probate an estate? Probate itself is the process by which a court is going to recognize a person has died and then authorizes somebody to administer that estate and distribute the estate, okay? And it's a simple process in many instances, but it can become very complicated in other instances. We're not gonna really talk about the complicated part today. Typically, the way that I characterize probate is sometimes it can be family law for the dead, okay? Because remember, in family law, which is my other primary practice, people are fighting. People are fighting about kids, they're fighting about property, they're fighting about assets. Here, we're talking about mostly financial stuff, and people fight and fight and fight about financial stuff. So that's the complicated stuff. We're trying to get rid of that. We're not going to talk about that. So who are our heirs? Our heirs are our children, like I said, including those from previous relationships. So, you know, if you have children or adopted children, or, you know, someone that you may have even said is my child without actually doing any of the legal processes to make them your child, could potentially be considered your child, depending on certain things. So, you know, it can be your stepchildren, it can be, it cannot be your stepchildren, and it won't be your significant other, but it would be a husband, since it's all women in here, so I'm saying husband. It could be a wife or a partner, and it would be your children, and like I said, siblings and potentially parents. It wouldn't be stepchildren unless you have adopted them or specifically put them in your will. It wouldn't be friends unless you have put them specifically in your will. It won't be your paramour, boyfriend, girlfriend, whatever, unless you specifically put them in your will. They will not inherit unless they can somehow prove that they were common law married to you. Okay, and don't let them get you common law married. I have a YouTube thing about that. Go listen to that. How to not let someone prove that they are common law married to you. It's not what it's called, but you'll see it. If you die without a will, it can be a lengthy process. Okay, so a part of this is when you go to probate, you'll hire an attorney. They'll file a probate application, and I'm just going to give you a quick rundown. They'll file that probate application. It'll say, we need to probate this will, or not will. And then they're going to hire another attorney. The court is going to appoint another attorney to go and find any errors that weren't listed in your application, okay? So you're not only paying for your attorney, but you're also paying for this other attorney. Not too much, but they still have a job to do. And then it could take time to get through all of that. So it can be lengthy, it can be expensive. Typically it's paid out of your estate eventually if you have an estate. All right, so yes, sir.
So a couple of questions. When you look at, in my family, a lot of people passed away without a will. Mm-hmm. And we found out later that if they had assets like a house and things that needed to be probated, there was a cost to go through probate that people didn't really know about, because some people passed away and we had to come up with money to pay for the services.
Right.
So I want to talk, if you can talk about two things at some point. How do you avoid probate for someone who doesn't have the assets that are probatable? Mm-hmm. And then if you have to go through probate, what people should do to be prepared for the cost of probate? And how much does that cost usually to go through it?
Right. So I will talk about the first question in a little bit. The second question, how much does it cost? Depends on who you hire. We all are different costs. Some people do it flat fee, some people do it hourly. Typically, if it's a simple probate with either a will or we know who the heirs are and everybody kind of is on, the same page, it doesn't cost that much. Maybe, it could be anywhere from $1,500 to $5,000. It only goes up from there depending on how contested the issues can be. Yes, ma'am.
So I've always been.
Hold on, I gotta do this so we can record it.
Okay. So I've always been told not to get a will, but get a trust. And is a trust in an estate plan, or is that just separate?
Okay, so I will also talk about that in a little bit. And when they talk about trusts, they're talking about doing something called a revocable trust. And
Or a living trust?
or that's right.
same
We don't really have living trusts here in Texas. That's actually a phrase out of other states. What a living trust in Texas is a little bit different. It's not really a probatable issue. But what it would be is a revocable trust, REVOCABLE. Please come in. And what that is you put all of your assets in this trust and determine who the executor will be, or the administrator. It's usually the trustee. I'm sorry, the trustee would be.
And that would be yourself if you're living,
And
you
then-
put someone under you.
Correct, absolutely. Those are more expensive plans to put together. So really those are more geared towards people that have more than just a house. It's more for people that have significant assets that could potentially have tax consequences.
But trust, you don't have to go to probate.
Correct.
If you have an estate in there, like
So
any real
long,
estate.
so long as it is correctly, so long as it is correctly funded, yes. And so those are types of questions that you would want to go talk to an attorney with, especially if you have more than one property. And we will talk about homestead property, because if you only have a homestead property, you don't need a trust, and I'll tell you why in just a little bit. But if you have multiple real estate pieces, like you have maybe a series LLC with real estate in it, then definitely you would want to look at a trust instrument to take care of those items.
One last question.
Sure.
You also said that it has to be correctly named as like not your primary. So what do you mean
Correctly funded.
funded? What is
Yes.
that?
So that means that you have actually transferred all of the assets into the trust, and not just kind of had the trust made and then not actually transferred the assets into it. Because the trust has to own the assets. You can't own them by yourself. So if you bought a house, like I just bought a house, if you bought a house today under your name and then you decided to have a trust put together, you would then have to transfer your property into that trust name. So, yeah. All right, so yes, sometimes you don't need a will, and we'll talk about reasons for that, and sometimes you do. I think that a lot of attorneys prefer that you have a will, and that way it's just so that we know exactly what you want, even if you don't have assets that really necessarily have to be distributed. Because what if you just have some jewelry or something that you want to give to a specific person, right? You can do what's called a holographic will. I don't have that in the slides, but a holographic will is literally you writing your own will in your handwriting and saying, I want these things to happen, with these items. So on the YouTube channel, I told Clifton to put on a website that has a lot of free legal services. I think it was Texas Law. What was it again?
Yeah, so Texas Law Help. So if you're watching online, it's in the description of the video. There's a link to other resources, so you can look at that.
Right, and that has kind of, it's really where I got a lot of my information today, other than what I already knew, and it has a lot of forms there as well for people that may need wills or don't need wills, and even some simple wills on there. Again, as an attorney, I would advocate for you hiring an attorney to draft your will and not using a LegalZoom or any of that kind of stuff. They're always wrong. So, and not because the forms are wrong, it's just they're always wrong, and it's just something that we have to deal with. Okay, so things that don't pass through probate, okay? Things that you don't necessarily have to have in a will. Named beneficiaries, joint owners, and payable on death accounts. So what is that? Some assets just don't make it. If you have an insurance policy through your company, through whatever, you've gone to a financial planner and put together an insurance policy, and it's going to pay out, that doesn't pass through probate. No matter what happens, it never passes through probate. You have a name designated beneficiary, and once you've passed, the insurance company will contact that beneficiary, or your beneficiary needs to contact that insurance company, and they will distribute the money. Okay? It goes straight to that person. Nobody can fight about it. It's whoever was designated. So make sure please make sure that you have updated your beneficiaries if you choose that the person that you have designated right now isn't someone that you want to have that money should you pass. All right. Retirement funds. So if you have any retirement funds through your companies or through financial planners, again, those have named beneficiaries already, and those don't pass in probate. And then bank accounts. When you guys sign up for bank accounts, they ask you, do you have somebody that you want as a payable on death person? Those don't pass through probate, okay? But if you don't have somebody designated, then it will have to get probated, all right? So just be aware of that. Yes.
So clarifying, so the basic, the cornerstone document of an estate plan is a will.
Yes.
And a will basically gives instructions as to who do you want your stuff to go to.
Yes.
So, and you've got to go through probate. But if you want to avoid probate for these type of accounts, the first action that we should all have to do is go to your bank, go to your company, your retirement accounts, your insurance account, and make sure that you have listed a person or somebody as a beneficiary to your accounts.
Yes.
Because if you don't do that, it will default to your estate, and that is probatable, and you need a will to determine who that goes to. Right? Okay.
Correct. So if you don't have a named beneficiary, it does default to your estate. Now, for those of you that have children that are under the age of 18, do not designate them, okay? You need to designate someone over the age of 18 because insurance companies specifically will then make you have to go get a guardianship, which can be expensive, okay? Because even if they are your child of your blood, they still are like, well, you don't have rights to, or they don't have rights to all of your stuff without them being 18 yet. So just make sure that you have someone that you trust. Yes, sir.
So I'm going to ask another question, because as a financial advisor, one of the things that we always recommended is if you have a child under the age of 18, and let's say you put as a beneficiary your brother, and you trust your brother, what you've legally done though is you've given your money to your brother, and your brother does not have to legally give that money to your kid.
Correct.
So that might be a situation where later on you can talk about setting up a trust or a testamentary trust within your will so that legally it goes to the benefit of your children.
Right.
As opposed to just trusting in the goodness and the faithfulness of your relative.
Right. Absolutely, absolutely. And let me tell you, I mean, within my own estate plan, I have a testamentary trust. Those are kind of beyond, those are things that you really need to talk to an attorney about for the specific instances of your situation. Because, I have specific people that I would want to administer that money, and I want it to go to my children and not used for whatever your brother wants it to be used for. So other assets that pass to your beneficiaries that you named is if you have a joint bank account. Say you have a joint bank account with your sister or your brother or your spouse or whatever it may be. If you die, it automatically gets transferred to them because they're the joint person on that account, okay? And then real property, which is held jointly with a right of survivorship. Now, so that's obviously somebody who also owns your property with you, and you have specifically said that they have a joint right of survivorship. Typically that happens with spouses. They make you sign that, and immediately that property will transfer to the spouse, okay? You can do that with other people as well. It's just more common with spouses. Yes.
So I'm asking questions that other people have asked.
Absolutely.
So what some people do to make sure that their loved ones have access to their money when they pass away is they sometimes just create joint accounts, or they put somebody else's name on their house. And I wonder what you advise people to, because when you do that, you really are like they have ownership to half of your account. And if you only want them to have it if you pass, and you've added them as a joint, that means if they have any claims against them or liability suits, they can go after some of your money. So how do you really recommend that people avoid that type of liability?
I would do it as a bank account payable on death. versus a joint account. So I would definitely designate it that way. And as a joint person on your account, they own all of it with you. You own it jointly. All that money is both of yours, okay? So it's better to do it payable on death. Again, check to make sure that your beneficiary information is updated. You know, think about it every year. This is just something that you should think about. I know death isn't fun to talk about. We're just, you know, here unfortunately talking about it because everybody, it is an eventuality, and we want to make it as easy as we can for our significant people in our lives. All right. So I wanted to quickly move off of the wills and talk about ancillary documents. And what those are things that happen if we are still alive and need help. All right. So we have powers of attorney, and it is something that gives another person the right to act on our behalf, you know, if we become incapacitated. Now, what does incapacitated mean, right? Does that mean that I just like am asleep in a hospital bed? No. It means that you legitimately cannot make decisions for yourself. In a coma, you have dementia, you are in the middle of a surgery and you can't be woken up to make a decision, although they try and make you make decisions beforehand in hospitals. But, you know, in situations where there are significant things that need to get done on your behalf and you aren't able to do it for yourself. So you can make them broad, you can make them limited. And typically when attorneys are talking about powers of attorney, generally, that is a power of attorney over the person. Over the finances. So you can do a financial power of attorney and you can do a medical power of attorney. And we'll talk about medical powers of attorney in a second. But basically, you know, the general durable power of attorney allows them to do everything except for make your medical decisions, like my little slide says. You can ask that it immediately go into place. Sometimes you can say it only goes into place when I become incapacitated and 2 doctors have said I'm incapacitated, okay? Or 1 doctor says that I'm incapacitated or something to that effect. So there are stop gaps. Now, when I was married, my husband at the time had a general power of attorney that immediately went into place should I, he had it. So he could sign documents on my behalf if I didn't want to go to a closing for a house. He could go make decisions, financial decisions for me at any time. We talked, obviously. He wasn't going to just go do that without my say. But you can have it start immediately if you trust somebody enough. But typically it's, let me have a doctor say that I'm incapacitated first, okay? I don't have anybody like that now, so I don't, everything is on incapacity, right? Because I don't have a trusted person that I would allow to make those decisions for me. And I would hope that unless you are in a very trusting relationship that you don't have somebody that would be willing to do all of that. So powers of attorneys are really important. They're basically forms. Attorneys will do them for very cheap. Talk to your attorneys about exactly what you want, when you want them to kick in, what items you want somebody to have authority over. Is it just financial? Can they go into your bank account? Can they do this? Can they make, you know, signing decisions for you? What can they do? Okay, attorneys are very well versed in all of that. They can talk you through it. This is a very big thing. So advanced directives are a little bit different. Advanced directives can be your medical powers of attorney, but there are also other advanced directives that we're talking about when you go into a hospital, and it's like the do not resuscitate advanced directives. They're different, okay? So if you want an advanced directive in place, and it's about medical care and end-of-life decisions, somebody else making those decisions for you, should you be in a nursing home, incapacitated in a hospital, whatever it may be, that's what a medical power of attorney will do. If you're on Medicaid, it'll give them the ability to also, you know, apply for your Medicaid or your Medicare or whatever it may be that you need help with. So it provides your person the ability to talk to healthcare providers, make decisions about you and your medical case. And it doesn't, again, go into effect immediately. It happens when you are incapacitated and your physician says, hey, this person needs help, okay? I do guardianships as well, and guardianships are for children and for adults. And I get phone calls from nursing homes all the time asking, hey, we need someone to make some medical decisions for this person because we cannot legally, okay? Who do you have that can volunteer to do that? And please start a guardianship for us, right? So sometimes you guys don't want me as your attorney. Not that I'm not a good attorney, I'm not gonna find you a good person. You need to find someone that you trust to make those decisions for you, okay? Do you have somebody that you trust, that you've talked to, that you've said, if I am in a coma and I don't have a good prognosis, I want you to do X, Y, and Z. Or I want you to not do X, Y, and Z. I want you to keep all the life support going, okay? So there are things that you need trusted persons to do for you. Sometimes that can be a child, like hopefully your adult child. Sometimes it's a loved one or some other, sibling or whatever it may be. On that website that we have listed, there are free forms and instructions for these advanced directives. You can use those. They are promulgated by the state. They are very specific. Attorneys use them because we can't really change them. They are check the box type of situations, but definitely if you don't feel comfortable with the words in there or whatever, talk to an attorney about those advanced directives. Yes.
So it sounds like the will is a cornerstone. That is used once you've passed away.
Right.
But then these other documents, the power of attorney, the advanced directives, are forms. It sounds like they're not as complicated as a will, and you can get them done for free. Like I'm looking there, it says it's available online for free. Mm-hmm. It might be prudent to ask ask an attorney some questions. But what is the major difference between why a will, you advocate not using the online forms for a will, but you can use the online forms for these?
These are specifically made by the state of Texas. They are state of Texas forms that are like they have the correct legalese and everything in them, and you can't change them. You can't cross anything out. They are literally check the box.
Are there forms like that for every state? There's a website for other states?
Probably. I mean, I don't practice in other states, so I really don't know the answer to that. I just don't look outside of this state. Yes, ma'am. We've got.
And so note also, if you ever find yourself,
You got to have a mic.
note also, if you ever, and this is to the audience, if you ever find yourself in a position where a loved one arrives at a hospital or you arrive at a hospital and you don't have that documentation with you, because maybe you went to the hospital not planning to stay and not planning for your diagnosis, please know that you can have these documents crafted for you at the hospital at no cost. So make sure that you're aware that you can ask at any hospital. Generally, the hospital will have either a notary or someone on staff that can do it, or they can get a notary there to the hospital for you. Yep. So just FYI. Well, I work at UT Southwestern, and for UT Southwestern, it is the Office of Spiritual Care and Support that would do those documents for you. We get those calls on a daily basis. So.
Yes, absolutely. And definitely, or if you do have one and you don't have it with you, you can get it done right at the hospital. Because like mine is in a safe somewhere, right? If I'm on my way to a hospital, I'm not sure that I'm going to have all of my documents with me when I go. So what happens if you don't have a medical power of attorney specifically? And you probably know this very well. With no agent in place, people can still make decisions for you. If you're married, your spouse can make those decisions for you without any of the advanced directives in place, without your medical power of attorney in place. Your adult children, who has a waiver and consent, can make those decisions. Your parents can. And then obviously someone that you have clearly identified to act for you. So you can be in the hospital and say, I allow this person to make these decisions for me. Again, I would advocate for very quickly asking, if you're in that situation, asking for someone to get you some forms so that the hospital has kind of done a CYA on themselves, because that's really on them. And they don't want to be liable for allowing somebody to make a decision that legally cannot make a decision for you. Okay, obviously your spouse can, and your children can, and things like that, relatives can. Okay. All right, so the difference between the medical power of attorney and an advance directive is the advance directive is very limited in scope. Instructions about continuing or withholding life-sustaining treatment in a terminal condition situation. And it's very clear. Terminal condition is you are going to die in the next 6 months, and they have documented that, okay? Or instructions about continuing or withholding life-sustaining treatment if you have an irreversible decision, you cannot care for or make decisions for yourself, and you are expected to die. Not in a terminal condition situation, but you are expected to die. Okay, so those are the two scopes that an advance directive would talk about. The medical power of attorney isn't only limited to these life-sustaining things, treatments. It also talks about other decisions that can be made, such as I'm in surgery and I can't make a decision and we haven't talked about this. All of a sudden something comes up. Who's going to make that decision for you? Okay. All right. So how do we get our houses transferred if we don't have a will and we don't want to go through the probate process? There are limited situations where you can do this, all right? If you own one house and it is your homestead property, everybody knows what your homestead property is? It's the one that you live in? Yeah, it's the one that you get all the discounts on from the property tax people that really charge us way too much. If you own this one house and perfect, thank you. And, okay, so you have this one house and you don't need to go to probate. You don't necessarily need to go to probate. And the reason for this is, if it's your homestead, it can pass through some deeds that you can do beforehand, okay? So that you don't even have to do a will, all right? So, transfer on death deed. You can have an attorney. This is something that I would have an attorney do, all right? There are forms, there are sample forms. I would still advocate for an attorney on this. It won't be too expensive. It allows you to name a beneficiary in this transfer on death deed. It's literally a deed. And it will transfer to that person once you have died, immediately. But it has to be signed, and it has to be filed in the deed records in the county where that house is. So, my house. If I live in Dallas County. If I knew that I wanted to transfer that house to, I don't know, my mom, okay? Because my children aren't old enough. I would do a transfer on deed death and say, this house goes to her immediately upon my death, and, I would file it in the Dallas County records, okay? Make sure that it's all done in there. It doesn't affect your ownership rights while you are alive. That is not something that would happen. So you are totally fine doing this. You can still sell it. You can use it as collateral. You would still get your property tax exemptions. The person that you're transferring it to has no rights to your house until it has officially transferred after you have died. Okay? So, yes, sir.
If you have any liens on your house, would the lien transfer to the new person as well?
I mean, a lien on a house. Yeah, it would stay on the house.
And then what about if you have any claims against your estate? Would they have claims against your house if it's transferred upon death?
So that is a question that I actually don't have an answer to because I'm not fully a real estate attorney. I would advocate to go talk to an attorney about that, a real estate attorney about that specifically. So I don't want to say the wrong thing where I'm forever on the YouTubes. So if all you have is real estate, this is a very simple way to make sure that it goes to the person that you want to inherit. The same thing with your vehicles. I think we were talking earlier. If you only have vehicles, those actually don't go through probate at all. You just, unless for some reason you have a will and you want it to go to a specific person, but you can have all those documents ready to go so that they would transfer. There are forms at Texas DMV for how to transfer things after death without having to go through probate.
I have a question. What if you have, if you want to do the transfer on death, but you want to have two people named, is that possible?
Yes. So they would just be considered joint tenants at
Joint
that point.
tenants,
Mhm.
Okay.
Yeah.
So like if you, say your spouse and an adult child, and you don't want one or the other to sell or something, you want both parties to be entitled.
So-
you would have both on
Your
that
spouse
deed.
would already, is it a house that you owned as separate property, or is it a house that's owned as community property?
A separate property.
Then yes, then that would be if it's not your, and it's your homestead where you and your
Yes.
spouse live. Okay, so there's a little bit of a complication there. Your spouse might have what's called a life estate, where they would live in the house until they die, and they would be liable for taxes and things like that. So that's a little bit more of a complicated question, which is why I started asking more questions, because I needed to know all the facts. But typically, yes, it shouldn't be a problem to have two people to have a house transferred to two people.
Okay.
Okay.
Thank you.
Any other quick questions? Okay. All right, life estate deeds. So this deed is a little different than a transfer on death deed. And it transfers your real property to your beneficiaries while you're alive. So now they actually have the rights to that house, and nobody can sell the property unless everybody on the deed that you have transferred it to agrees. Now you're still liable to pay all the mortgages, you're still liable to pay for all the taxes, you're still liable to pay for the repairs because you're the one that's living there. What you've been given is a life estate in that house. Basically, you have deeded, so let me explain it a little bit differently because I think I made it really muddy. So you own the house, and what you're doing is you're giving yourself a life estate that says, I am giving myself the right to live in this house until I die, but I'm already going to transfer this house to my beneficiaries now, and I will not be allowed to sell this house unless everybody that I have transferred this house to says I can. Okay?
Who does that?
Nobody.
But it might be somebody, right?
It might be somebody, but I would not advocate for it.
Yes.
Yeah.
They're very old.
Right.
Right.
Yeah.
Exactly.
Yeah.
Exactly.
Right. Yeah. I would not. This is a very special type of deed. But typically what happens is that there's an automatic life estate deed that comes into place if you have a spouse. They have a life estate in your property typically, which is kind of why I was asking those questions earlier.
And this also is used, or this type of strategy is used if you're in a situation where most that we're talking about is when you pass away. Your will and how our assets that are in your name are transferred to your beneficiaries. But there are situations where while you're alive, because of your estate, it is beneficial for you to start putting your assets in other people's names while you're alive.
Right.
And this is one strategy where you can put your house or real property into the names of a future beneficiary, but you have the right to stay in that house for your life.
Right. And so if you're in a situation like that, there are attorneys that specialize in Medicare spend down things. I am not versed in that. I will 100% tell you I'm not comfortable with that part of the law. But there are attorneys if you need Medicare and Medicaid, and there are spend down provisions and things like that when you need to start transferring funds before you need those services. That's the type of attorney that you would want for maybe a life estate deed type of situation. Ladybird deeds is what people used to use. They still kind of use them a lot, but everybody that I know of, as far as all the attorneys that I know, have shifted over to transfer on death deeds versus ladybird deeds. This is more for, again, the Medicaid spend downs and things like that when you're doing long-term care planning. And so, you know, it gives you the right to live in it, sell it, mortgage it, but it also gives a transfer, you know, later, and kind of helps with those Medicaid spend downs. You know, so again, something that you would talk to an elder law Medicaid planning attorney type of situation. Okay, so burial insurance, living trusts, and annuities, and I told you that we would talk about living trusts in a little bit. So prepaid funeral contracts, use caution when you're doing those. I don't say don't do them, but just make sure that you're reading those contracts and make sure that it will survive you, basically, because you want to make sure that your family isn't having to spend more after you have passed. If this is what you're planning to use, you're doing burial insurance or something like that, make sure that it will cover what you need it to cover. Okay, living trusts and annuities. Annuities are where you pay into I think Clifton would probably be able to answer this better than me. You pay into something and it's kind of an insurance proceed that you are getting paid over time, right? It's just, you constantly do that. Just make sure that funding them is actually beneficial to you. I'm not going to go too much more into it. Again, with the living trust, if you only have one property, you're better off doing a transfer on deed death versus putting it into a trust itself. Just because funding the trust, getting a revocable trust, those plans start at $5,000. So whereas you can get a regular will a lot cheaper. Okay, so that's kind of where we're at with that.
But the trust, forget that.
I know.
But the trust eliminates probate. Just having a will, you still go to probate.
Not necessarily.
Okay.
Yeah.
And I would like for you to explain when it's not necessary.
Right. So it's not necessary when you really don't have assets. So like if you have a transfer on death deed, then, and that's all that you have is your car, insurance proceeds, a bank account that's going to be transferred upon your death, or held jointly or whatever, all the things that we've kind of talked about. You know, if these are the only things that you have, and you can use other forms or other deeds or other items that will automatically transfer those things to your beneficiaries, you don't need a will. Okay, so
it doesn't go to probate.
it doesn't go to probate.
Because that's what I'm.
Right.
Because I'm in real estate.
Sure.
And I feel like a lot of people still go probate.
Yes.
And it's because they don't have the transfer deed.
Right.
And so that's what I feel like we need to hammer on is people to actually do the deed.
Right.
Because people are getting wills, don't have the deed, then it's going to probate, and then people are like, what? I thought I planned better, but they didn't.
Right, and now they've spent
Correct.
a lot of money to just get a.
And that's the
Right.
loophole that people need to continuously remember.
Right, absolutely. So thank you for making it very
we
clear.
need to- we need to
Yes,
say that louder.
yes, make it very loud. You know,
but I just-
yes. So absolutely, you definitely, if things can be transferred without having to go to probate, if there are forms out there that say, or deeds out there, or beneficiary documents that you can do, if you have little stuff for your will, go ahead and put together a will. Make sure that things it's more of this is what I want my family to do. They don't have to probate that will. They only need to probate that will if there are assets that haven't been transferred that need to be transferred, okay? So a will is more of this is just what I want to have done.
It doesn't mean it necessarily will happen.
Right, it doesn't mean that it'll actually happen.
And one of the things is that it's great having these kind of workshops because now you all have the opportunity to ask an attorney these type of questions to get clarity on some general questions. The Empower Series advocates for you to also talk to a financial advisor. So when you look at a financial advisor who's more aware of your financial assets and working with an estate planning attorney, they can talk through the right strategies to ensure that you're transferring your assets to your beneficiaries with less drama. And when you look at people who have a trust, because you hear, oh, okay, I need a trust to bypass the will probate. If your assets are not at a certain level and you put things in a trust that requires a trustee, a beneficiary, and then fiduciary management, if you don't have enough assets, it's not really worth it.
Right.
You might avoid probate for your family, but then you've created a situation which is a responsibility of a trustee, and a family member has to take that over. And if you don't have a family member that's responsible enough, they have to hire an attorney or corporate trustee. And if you don't have enough assets to pay for that over the life, then it may not be the right strategy for you.
Right.
So really talking to a financial advisor along with an estate planning attorney is what you should do.
And I'm done asking questions after this, guys. Sorry.
They are great questions.
You're asking questions other people have.
Okay. My other question is, what would you say, quote unquote, the level you need to be at to get a trust? Because if it starts at $5,000, and how many assets do you need to have where it makes sense? Because like he just said, you don't want to have a trust and then it's transferred and people don't even know what to do with it, and you've paid for this and now it's kind of just crumbled.
Right. So typically, if you have more than just the house and the cars, okay. So right. I mean, even so, with one, I would say you could probably still get away with a transfer on death deed, but once you kind of hit, I mean, I would say if you're somewhere above the 300,000 threshold, you might really want to think about it, moving everything in the trusts. Right. So the next thing that I'm going to talk about is what's called a small estate affidavit, and that has a limit of $75,000. So anything. So I'm kind of hesitant to say 300,000, 75,000. You know, it's just
varies,
it does vary.
This is 2023.
Right. It could definitely, and a lot of it is. Do you have a question real quick? You know, a lot of it has to do with really just what it is. So let me go ahead and have you ask the question, then I'll go into what a small estate affidavit is, and then that might answer some more of that.
So some of the things that an advisor would talk to you about, along with an estate planning attorney, is that if you have real estate in multiple states, that's a consideration of using a trust. The value, a lot of times when you look at a trust, and you may have, it's important to have liquidity in your trust.
Right.
In liquidity, I think at a minimum, for a lot of financial institutions, require you to have at least $500,000 of liquidity, you know, to make managing that trust and getting advice and filing the taxes for that trust worthwhile. But it all varies, and I think it's important for you to educate yourself on it now. It might be a situation where you create a trust, you don't have those assets now, but the trust is going to be the beneficiary for your $1 million life insurance policy. So when you have a life insurance policy that is of significant value and you want to make sure that that's being managed properly, there might be a strategy where you create a trust that's going to be funded with the life insurance proceeds, where you will have the assets at that point in time.
Right, and so that's a strategy that you can talk about as well. Something that trusts are good for if you have children that are under 18 as well, and you have a life insurance policy that may end up funding that trust, you can name the trust as the beneficiary itself. And that way you have a trustee already set in place that is managing that trust to take care of your children when they're under 18 until something happens in the future. So, you know, and again, those are very like distinct personal situations that we talk about with our financial advisors and our estate planning attorneys. And just so that you know, there are different levels of estate planning attorneys out there. There are some that deal with very high net worth clients, and so those estate plans are very expensive because they're very complicated. And then there's some that can do a simple will for a very reasonable amount of money, and they're just talking to you kind of about what I've been talking to you today. You know, where do you want your stuff to go? Who do you want to take care of your kids? Who do you want to take care of you should you need that? You know, those are a lot more simple questions to answer rather than all this complicated stuff. Now, attorneys, no, you're not, that isn't a sorry question at all. You're asking wonderful questions. Now, I advocate for, if you have a financial planner, getting that financial planner to have an attorney on, like, that they call, because they can't advise you on the legal stuff. They can advise you on the financial stuff, and trust me, attorneys don't want to advise you on the financial stuff. We want to advise you only on the legal stuff. So having a financial advisor that has a good relationship with a good attorney is, worth its weight in gold. Okay? Yes, ma'am.
I just wanted to make a comment, which is for people not to forget about your employee assistance programs, because a lot of times they can refer you to lawyers or give you a list of lawyers, and also provide like a 30-minute consult that will save you money at some point.
Right.
So.
Yeah.
And we
those-
also have a legal plan, this is my employer, that we can purchase each month. So pay a nominal fee each month, but the benefits are awesome.
Right. And absolutely. And like, I'm not on any of those plans, on any of those employment plans, because I try and stay a little bit at a different level of, because those are very ad hoc type of things. So I prefer to have clients that will come to me always. So, that's why my firm's name is Family Law, because I want you to come to me as if we are part of your family. But there are great attorneys that are a part of these plans that will do a simple estate plan for whatever that cost is with the employment plan, and they do great work. So I would absolutely, say do that if you have it available to you. And sometimes they'll say to you, I'm sorry, I don't feel comfortable doing that. I'll refer you to somebody else. All right.
And the fact is, over 60% of Americans don't have these conversations.
Right.
Or they have these conversations and they don't execute on them, because when you talk to people, you got to make decisions about who's going to be your executor, who is responsible enough in your family or in your circle of people to make financial decisions for you, medical decisions for you. So I do want you to share this experience that you've had with other people. They've come to you, you've asked them those questions, they don't have the answers, and what happens?
I ask them to go home and think long and hard about it. Sometimes that means that it takes them time. I mean, and so it can be someone comes in and they already know those answers. Great, we'll do that. But typically, sometimes they may need to go speak to a counselor to really go through all of that. Sometimes they just need to talk to their spouse and say, okay, well, can we come to consensus on some of these things? You also have to go ask the people. That's the biggest thing, especially if you're asking them to take care of your children. Oh my goodness. They don't want to be blindsided. So these are things that, as an estate planning attorney, I will say, okay, well, first of all, I'll send y'all a document that says we're going to talk about all of these things. So if you can answer any of them, please do. But don't feel like you have to answer them today, okay? Then we will have a meeting and we will talk through every single point more in depth. Usually in estate planning, the first meeting takes about an hour to an hour and a half, sometimes two, depending on the emotions that may come up, because there's a lot of things that you aren't thinking about until that moment. And then if we can't get answers, or if you say, well, I think I want my sister-in-law to take care of the kids, but I need to ask her, I don't want to just put her down. Okay, please go ask. Please do that. Or I trust this person to take care of the finances, but I don't know if they'd be willing to do it. Please go ask them, because they don't want, if you have a lot of money and they're not comfortable dealing with a lot of money, they may say, no, please don't, I really don't want to do that. So, so I'll send them home, and then I'll kind of just follow up and say, hey, have you thought about this? Are you ready to have another sit-down meeting? If I've got some stuff, I'll start going ahead and drafting what I can in the estate plan, or the, whatever it may be, and then we'll go from there. When I'm kind of at the last, like, hey, I need to know who this person is, I'll start pinging you more and more as we kind of get closer. But most estate planning attorneys aren't going to push you past a breaking point. We're very skilled at making sure that everybody is emotionally ready to make those decisions. So, does that answer that? All right, so the last little piece before I talk about guardianships, and I know that I'm actually going a lot longer. Okay, So a small estate affidavit is an affordable way to go through the probate process. So it's a lot cheaper than the actual probate process, because what it really is just an affidavit that everybody signs and it gets put into the courts. There's more to it than that. But so this is somebody that died without a will. Okay, you cannot have a will to do this. They left less than $75,000 in property, or just have a homesteaded property. That kind of is a separate thing. The assets are worth more than debts. So typically you can't have a debt that is going to take over all the assets. This is basically just we're just telling the court that this happened. They only owned one parcel of real estate, and it was their homestead. Okay? And it will only be inherited by those who were living on the property with the person at the time of their death. So it would be someone like a surviving spouse or minor children that lived in that house. Okay? You're able to locate all of the heirs, and all of the heirs will sign this affidavit and say that they agree. And there's no pending application. Oh, well, we were laughing. No, that's not going to happen. Is that? No, absolutely. Do you have a question? No. Okay. So you have to first be able to locate all the heirs and then have them all be in consensus. There are no pending applications for appointments of a personal representative, and there's no actual administration needed, meaning you don't need someone to go and start like paying off bills and, you know, paying mortgages and things like that. So this is a very limited scope situation. It actually happens quite a bit, and it's pretty easy so long as you fit all of the criteria. And an attorney would be able to tell you whether your the decedent does fit these criteria. Okay, so that's all that I have with regard to estate planning and probate. I'm going to switch over to guardianships real quick and talk maybe about 5 minutes, and maybe you guys will have some questions. So guardianships kind of go hand in hand with estate planning, a little bit in probate, but more on the estate planning side. In Texas, only a handful of attorneys are qualified to deal with guardianships. Okay? I am one of them, but it's really, we have to take special classes, special continuing legal education classes, and because there are different considerations that we have to deal with. So guardianship is where an adult has basically the ability to take care of either your personal affairs or your financial affairs, or both, regardless of whether you are an adult or a child. Okay? Typically this is somebody that is incapacitated in some way. You have a child with autism. You have a child that just is never going to have the ability to take care of themselves past the age of 18. An adult, once they turn 18, will absolutely need to have guardianship over them. Okay? So there would be a process that you also go through probate courts for, which is not surprising, but they're the same courts that deal with this, where you get all of the rights and duties stripped from that person and given to you. Sometimes they're limited in scope, sometimes they're broad in scope. It depends on how much somebody needs help with. But typically they have to be incapacitated in such a way that a doctor is going to sign off and say, this person isn't going to take care of themselves. Okay? This happens a lot in the nursing home situations where, bless you, where there is somebody who can't dress themselves anymore, can't get out of bed anymore, can't do all of the daily living functions. And this happens also sometimes when somebody is in their own home. So you need somebody to have the ability to take care of the person in those situations. And then on the other side, what if they have finances? What if they're getting, trust funds once they turn 18, or as an adult, they're getting trust funds, annuities, something that is substantial in monetary value? Who's going to take care of that stuff? That would be a financial guardianship. So, so when we talk guardianships, it's really important that, because I get a lot of phone calls about, hey, I need a guardianship over X, Y, and Z. And my first question is, well, is there a doctor that has said that they're incapacitated? Because if not, then we're going to go back to all of the power of attorney things, medical powers of attorneys, advanced directives. Can they make decisions on their own that they can sign these in front of a notary, and a notary would say, yeah, I think that they had capacity? Or has the doctor legitimately said, there's no way, we're never going to get there, or we're past that point, we have dementia now, and we're only getting some flashes of lucidity, right? So when situations like that happen, the attorney should, a guardianship attorney should, then start talking to you about what these items are. Because if we can, the way that Texas specifically is, and the courts are kind of told, is we want the least restrictive avenue for people in guardianship situations. We don't want to strip them of all of their rights if we can help it. And so if you are in a situation where you have an elderly parent that is starting to lose their facilities, or you have a child who's about to turn 18 that you know is never going to progress past a specific point, you definitely need to talk to a guardianship attorney to see what options there are out there for you. Okay? Any questions?
So guardianship, let's say, for example, I have an adult child with autism. I don't have a guardianship in place, but he's just, he's living with me. I have, my other kids living with me. If I don't put in place a guardianship where I identify who's going to take over that responsibility when I'm gone, then it's just left to, the best other sibling that can handle that, right?
Or the state. Yeah. Yeah, you don't want the state making those decisions.
Because it's usually the state.
Right, it usually is the state. Absolutely, because that is a lot of responsibility to put on a sibling. And it's a lot of responsibility to put on anybody. So, and I have seen siblings basically go, I'm not doing it. I just simply will not. And I know that is my blood relative, but I just cannot. So what happens? The state has to take over.
All right, so here's what I understand. So what we talked about was a will, which is the cornerstone of estate plan. We talked about the financial power of attorney, the medical power of attorney, the advanced directives. We talked a little bit about a trust, which I want you to go more into what a trust is and what's the difference between a trust and a testamentary trust.
Okay.
Right? But then we also talked about some other forms and things. I really want you guys to open up with questions, because this is an opportunity. If you haven't sat down with an attorney to talk about your situation, that you can make it very general, to ask questions, this is your opportunity to do so, right? I really would encourage you to, as an action after this, to talk to your employee assistance program, see what benefits you have at work, or connect with an attorney to ask these kind of questions. But can you talk more about what a trust is?
Sure.
And what a testamentary trust is?
Okay, so a testamentary trust is something that we put into a will that basically says, if my children are basically under the age of 18, this is going to be the trustee that's going to take care of the financial affairs. It's drafted within a will, and is kind of a specific section that's in there. Now, what I was talking about earlier, like a revocable trust, is where you're funding something with a trustee. So you already have assets and you don't want to go through the probate process. So if you have a testamentary trust, it still goes through the probate process, because now you have an administrator who's going to take care of all of the things. But a trust, a revocable trust, is something that would help you defeat the probate process. Now, we also have special needs trusts, which is something that you would put inside of a will as well for children that have some sort of special needs. And it doesn't need to necessarily be a child that is completely unable to take care of themselves, but this is a trust specifically used to help with their medical needs later on down the line, or any sort of, if there's finances, if they're going to need housing assistance or nursing home funding or things like that, that's what the special needs trust would be used for. Those can be drafted by both estate planning attorneys, family law attorneys, and guardianship attorneys.
And a special needs trust can be used, let's say, for example, you have a child that qualifies for state benefits, and they're going to be the beneficiary of your life insurance policy. So you don't want their income to disqualify them for estate needs. So you can make the special needs trust the beneficiary for those funds, so that the child still qualifies for assistance through the state, but yet there's additional money to take care of things that the state may not take care of.
Right.
So back to the basics of a trust. I want to assume that people who are listening may not know what a trust is. So the way I understand it is, you can own things as an individual, as a natural person, or you can have an entity own something. So we all know about business. You have a LLC, you have a corporation. A trust is a non-natural person entity that owns things. So that's why when you create it, you've got to fund it.
Right.
And when you look at the players of the trust, I want you to go through and talk about who the grantor is, who the trustee is, successor trustees, and beneficiaries of a trust, just as a definition, so that we can all walk with the basic understanding of what a trust is, whether we need one or not.
Right. So the grantor is obviously, the person that is funding the trust. It's you. You're granting the trust all of the stuff, all of your property. The trustee is going to be the person that takes care of everything within that trust. They'll make, if there's a property, so you say that you have funded this trust with properties, okay? The trustee would then make the payments on the mortgage, it's really you, because you would be the trustee initially, right? So they would be making the payments on the mortgage, they would be making all the financial decisions, they would be making, making sure that property taxes are paid. And if there are things like investments that are in this trust, that person would be making all those investment decisions as well. So if you need to change an investment or revise it or whatever, they can make beneficiary changes, things like that. The successor trustees are people that once you have died will basically take over, or if you're incapacitated, will take over and do all of the same functions that you have asked them, that you have been doing as the trustee, as the new trustee. Now, typically, as an estate planning attorney, I ask for you to give me 2, maybe 3 successor trustees, and in order of who you want to take care of something. And that's the same with administrative when we're talking about wills as well. Because somebody may say, I don't want to do it. So you need a secondary person that will, or a tertiary person that will say, okay, I'll step up and do it. And then what was the last piece the beneficiaries. The beneficiaries are obviously the people that would inherit. So, the trustee is one person, and then there's the people that are going to inherit. And sometimes the successor trustee can be someone that's going to inherit under this trust. And it's like, who is going to receive monies out of the trust? Who's going to get all of these items distributed to them, if you choose to distribute them out of that trust, or if you just want the trust to continue going into perpetuity. Well, you can't go into perpetuity, but for some time.
Which is what I was going to talk about next. So part of this, and this is where when you're meeting with a financial advisor or an estate planning attorney, they're going to ask you, if you're looking at a will, who's your executor? And then that executor may pass away. So I've got to update my will because I've had my brother perform certain roles, and then I had a secondary and a third. And so my brother has passed away. Some of my secondaries and thirds have told me that they don't want to deal with it. So I've got to update it, right? So the point is, when you're looking at a trust, you have to identify if the trustee passes away, who's that next person that's going to take care of managing the trust? And if we look at people who are our age, at some point, they're going to get older, and we got to pick somebody younger and so those are tough decisions to make.
Right.
And a trust does not die. But you've got to identify who the successor trustees are, who the successor beneficiaries are, and at some point, when will that trust be dissolved?
Right.
And those are some tough questions to answer. So it wouldn't be for someone who doesn't have a lot of assets. It would be for someone like, I'll just use a name like the Hiltons. You've got so much money, you don't want your crazy generations to mess it up, right?
That's fun babies. You don't hear people say will baby.
Right.
There's a difference, yeah.
So it is all possible because we all have ideas that are billion-dollar ideas if we're courageous and courageous enough to act on them. So if we want to think about creating wealth and generational wealth, it's a good thing to think about. You start where you are. Everybody started small, but every idea is a big idea. But to have these kind of conversations now, prepare for your future generations, because we always want our future generations to do better than us. And one of the ways to do that, in my opinion, is to get life insurance, understand what it is, and put it in vehicles that cannot be squandered.
Yeah.
And a trust is a vehicle for that. So if you can
Right.
talk a little bit about the secondary and the third, and how do you help people? I know a lot of times we are not taking actions on doing this because we don't have the answers. And as an attorney, you can't give the answers. But how do you help them really make sure that they don't procrastinate and just not ever come back to you?
Right. So, I mean, I make them pay for at least half of it before we start. So that's the first thing. But typically, it's just constantly pinging. I mean, within reason. Obviously, you're not going to get a ping every day. You're going to get an email or a phone call or something from staff members to kind of move them forward. But, you know, when you're talking about successor trustees, you're really talking about generations that may not even exist yet. And so, you know, when you have passed and you've got a successor trustee that has taken over, they're managing this trust pursuant to the wishes in that trust. And then you can even within that trust say things like, well, I don't want my child to, like next generation, right? I don't want my children to get X amount of money. It can be distributed on their 21st birthday, on their 25th birthday, on their 30th birthday. You know, you can make them very, very tightly drafted to kind of control people. We don't advocate for that, but we do try and, you know, if you think that your child isn't going to really make very good mature decisions until they're in their 30s, and you want to give them some money, but you don't want to give them all the money, that's kind of the vehicle to do that in. But it also goes into the further generational side of things. If you have Hilton type of money, those are trusts that are way beyond my capabilities. And I think that, you know, they have trusts that are born out of trusts. So depending on how those work. So, you know, when you're talking about a trust fund baby, like you were saying earlier, that is a trust that was made out of a first trust. There was a trust that was made, and now it's like distributed to a secondary trust that is distributing to a beneficiary as they age through the system and as they get older and more money, et cetera, et cetera. So those trusts are good in very specific situations. Now, testamentary trusts, I definitely do. If you're going to do a will, I think testamentary trusts are good because they're not something that gets funded right away like a real trust does. So that's more of, you can also do things like, I don't want my child to have money until they're 25 in a testamentary trust, but it's less restrictive than a trust itself is.
So our objective today in every workshop is to give people four things: hope, inspiration, education, and connection to resources. So first, hope. So we all have hope. We all have dreams and things that we aspire to accomplish. And you may have a dream for your family. Like the dream for my family is that I'm able to leave them with enough resources to weather through any valleys that they go through. And I really want to make sure that the experience that they have when I pass away is not, like I already know my son and daughter, it's gonna be crazy. But the point is, I wanna make sure my stuff is at least organized. And we didn't really talk about that. Like what we need to do before these documents to make sure that when they go into our home after we've passed away, they can easily see where the will is. They can easily see what my bank accounts are, what my insurance statements are. So there's a part of being organized that there's an article on that to make sure that you're organized before these wills are even executed. But my point is, I have a vision for there being peace and not a lot of mess. So I hope that whatever you envision, we've given you some hope that you can talk to a financial advisor, talk to an attorney, and manifest that vision for you, right? And that's number one. Number two, inspiration to take action. I don't care what that is. Like you're here today, that's the first step. Thank you for coming. Secondly, talk to your beneficiary, your benefit person at your job. If you have a job that has employee assistance program, get the information, take some kind of action, whatever that is, and I'll ask you if you feel comfortable sharing what that action is.
I'm done after this, I'm sorry, guys.
It's all right, we love you.
My question for you is, the action that I would like to take is to bring some questions to my parents and my grandparents, because those are the people I'm helping get all this organized, because I'm the organized one in the family.
Okay.
But what are the questions that I need to ask them so they can already be thinking about? So when we do get in front of the attorney, there isn't go home and think about it. They've thought about it.
So, I mean, what I would suggest is to go ahead and contact an attorney and get that form from them, because we have different forms. You can probably actually go online to that Texas Help, and there will be some. But typically it's, who do you want to take care of you should you become incapacitated? Who do you want the property to go to? Do you want everything split? If there is property, or whatever assets you may have, how do you want your assets split? You know, exactly equal amongst everybody? Is there someone that you want to cut out of your will? That's a question that you need to ask, because it has to be done a very specific way. Okay, so do you have jewelry, specific bequests or items that may not actually be a part of a probate, but that you want to give? You know, like, are there heirlooms? Are there, you know, things that you want this person to have because there's a special connection to that? Yeah. It's okay.
When you start speaking, it stems something else. So when I asked my grandfather about his retirement accounts, how does he go? Because he keeps telling me, it sounds like I'm totally after my people, but no, I just want everyone to be good to go. Just want to put that out there. Just want to put that out there. But on his retirement account, his ex-wife is on there, and he was saying that he can't take her off. So that's what I said too. I said, grandfather.
He'll talk about that.
Sure, so I want to be able to bring.
But you saw my face too, so that's not.
So this is where again, talking to your financial, I like being on the side, right? But this is where your financial advisor will be very helpful, and your grandfather should have one as well. But you have certain benefits that companies have that are annuity type benefits or pensions, where after you've been married for a certain length of time, you can't just cut out your spouse. So without knowing exactly what type of account it is, it's hard to say whether, you know, he can change the beneficiary.
Yeah, I don't think he can, because you said something about updating them, and I told him to update things to my name. And he said he didn't, so I was like,
So,
I figure out how not.
so a part of that is that,
Just being honest.
I mean, a part of that is there could have been an agreement in a divorce decree that says that specifically. Like, you know, to be candid, that's an agreement that me and my ex-husband have, is that our beneficiaries stay the same. So, because it only benefits our children. So, but I don't know about your grandfather.
He only has one kid.
Yeah.
I was just gonna mention just generically that if that person is military, that's a whole nother
Yes.
situation. So just think about that. I mean, and checking with the.
I agree. That whole military thing is a let's do a sidebar after. So my question is, you mentioned, I never, thank you for asking your questions. You have amazing questions, so thank you. Things that I didn't think about, but I should have been thinking about. So for instance, if and you may have seen this, there's I guess, an account where your grandfather has the ex-wife as the beneficiary. Okay, so have you seen where a divorce decree, because generally when there's a divorce decree, when there are pension accounts, there are quadros that are done after.
Right.
But let's say that there's some accounts where the quadro was done because the quadro only speaks to the monies that are to be divided. It only speaks to that pension money. It doesn't speak to beneficiaries.
Right.
I don't remember. So would that decree trump the beneficiaries listed on the retirement accounts from the company? Have you seen that?
So before we kind of get into that, let's talk about what a quadro is. It's called, what it is a qualified domestic relations order. Thank you. And those are done in decrees, and sometimes they don't get done. Okay. So when they don't get done, the person that is supposed to benefit from the quadro, the person that is supposed to receive the money, is the one that should be getting those quadros done. Technically, they can get it done after the divorce decree has been taken care of and we are multiple years down the line, they can reopen the case and ask for that to get signed. It's just a small nominal fee. So yes, the decree would trump, but they would have to take the appropriate steps to do that. And also I have seen decrees that specifically say, you know, typically what happens is a divorce decree kind of makes your spouse dead to all the beneficiary stuff. Technically, they should be immediately removed. You know, once a divorce decree is given to a financial advisor or something, they're supposed to say, okay, well now, who's your new beneficiary, right? Because this person is quote unquote dead to the retirement account. But if the divorce decree specifically then says, we will redesignate each other, that would then trump any of these situations. So, mine does. Mine has us redesignate each other. Yes. Yeah.
This was not my original question, but since we're speaking of quadros, say if you have one in place and you get divorced, and in the paperwork there's a certain length of time to file and to receive funds, one or the other, and you let that length of time pass. Is there a statute of limitations
So
for that spouse to come back to get their share of your pension plan or whatever funds are available?
it's really up to the plan administrator. So it would depend on the plan itself. Yeah. So is that kind of what you were gonna?
No.
Okay. So typically, so there is an avenue where someone who hasn't done a quadro in, I mean, I've seen them in 20 years. And all of a sudden they're like, oh, wait a minute, I'm supposed to get this pension money. They can go to an attorney and that case can be reopened. But at that point, it's really, if the pension itself has limitations, then the plan administrator would be the one that would take care of all of that.
Okay.
Yeah.
So like in the decree, it had a specific timeline, and they did let that pass.
Then
So is there a statute? I mean, is it exhausted or expired because they let that time pass?
Yes, because they were contractually bound or told or ordered to get it done in that time period.
Okay.
Yeah.
Okay. And the second question I had goes back to the estate planning, and I understand the will versus trust, and you know your need for one or the other.
Right.
But say if you're just moderate and you just have the simple things, you know, the home, the dog, the car, or whatever. What is that package? Can you go over that list again of the forms that you need to have in place to have a complete package to know that you have protected or
Yes.
made your, you know, desires known?
So I would start with the will, and then in that will would have most of that in there. So, I mean, I have a lot of dogs, and I would want someone to take care of my dogs for me, obviously. But typically, you start with the will. And then we talk about ancillary documents. So those would be how to take care of my remains. You can do one of those. Your medical powers of attorneys would be a part of it. Your financial power of attorney would be a part of it. All your advanced directives, yes, would be a part of it. And typically each attorney kind of has a package that they'll put together for you, because here's the thing, once we've drafted a will, the rest of them take like no time at all to draft, which is why you'll see attorneys say, why don't you go ahead and do the will and I'll do all the ancillary documents for you, because all the time is in the will. And you know, we've already spent 2, 3, 4 hours on the will itself. It takes us 10 minutes to do the rest because all the information is already given to us. Whereas if you're going to ask us just to do the ancillary documents, it's going to take us longer because we still have to ask the same questions, only for smaller pieces. So, but each attorney, I mean, those are the big ones. If you have children, you would want, you know, guardianship type of documents, like who do I want my kids to go to? Who should they live with? There are specific forms as well out there where you don't actually have to grant guardianship to a minor child. You can kind of just say these people have the rights function kind of as their parents. And schools have those documents as well. They're used to seeing them for minor children. So those are the big ones.
And
Yeah.
guardianship for yourself.
And right. And the guardianship for yourself would be in a will, typically.
Would it be? Okay.
Yeah, yeah.
So this is great. So the third part, the second was inspiration, take action. Third is education. Are you getting educated right now?
Yes.
Yeah.
Good, I'm glad.
The last piece, though, is connection to resources. So, again, underneath and I'll make sure that everybody has the link, but underneath the video in YouTube is a link to additional resources. If people want to get in touch with you, how do they get in touch with you?
I have a website as well, and I've got my cards up here. I think you can put my website online, but it's my first name at famapplaw.com. It's hard to say it because it's a lot of letters that are very difficult, but please go on the website and either find me. My name is very unique, so if you find me, you found me. You will not find somebody else. And then, I typically answer emails better than taking phone calls, and my phone number does take text messaging as well if you need a quick, I'd like to schedule an appointment or something like that. And, typically that first meeting is, I do free consultations, and during that first meeting, it's really about what do you kind of need, and then I'll give you a price if that's something that you want to move forward with and go at, from that point, then we would talk about engagement and things like that. Yeah.
So I would tell you, if you're in the state of Texas, right, one action that everybody should take is at least the consultation.
Yes.
It will be valuable for you, because I don't know of anyone who did not get value out of sitting down with an attorney to ask specific questions that you may not be comfortable asking in an open setting like
Right.
this.
Yeah.
So definitely, this is not the end. This is just the beginning. Don't let this be the end. We have another workshop next month on the third Saturday where we're going to talk about putting this all together. If you're watching for the first time or here for the first time, on the back of the flyer in front of you are the topics that we address throughout the year. January through November, we address different topics. December, we get a break, but we start back up in January with the vision. Next month, we're going to talk about putting this all together again. Stay connected with us on social media. Don't keep this a secret. Share it with somebody else. If you're here, you missed it. But good thing, we're recording this. So you'll see the live program is going to be there for the rest of the day for sure. Then we're going to edit it and put the condensed version on there for you. And you can go back and look at other programs that the Empower series have done. If you haven't subscribed to the YouTube channel, do so now. Do so now. Right,
And I
right,
just
right.
wanted to very quickly say there are attorneys that do free consultations, usually, so that you know, free consultations won't give you legal advice. Typically, they may answer some questions. If you want legal advice in a consultation, they will charge you their hourly rate, whatever that may be. So just be aware.
Like nobody works for free.
Right.
So just like now, you're getting general information. It's not targeted specifically to your unique situation, but definitely talking to a financial advisor or an estate planning attorney will give you more information than you have today. It's worth doing. So definitely take advantage of it. I want to thank you for spending time with us online. Be a blessing to other people. Thank you. Are we cutting it off now? Online, right? All right, so I'll see you next month. Stay connected with us on social media. And for the people who are here, oh my gosh, thank you. Was this not great?
It's great.
Give us some love.
Thank you. You guys were great.
Yeah, we're done.